I don't have to read it, Malaj. Your lordships may take it that that's correct. We'll waste time otherwise, Malaj. So the primacy is of the party. The legislature has no identity other than being a representative of the party. Kindly see that 67 of the.
That's okay. I think you've paraphrased it, and there is no reason to doubt it.
Right. The reason is what he sends is that he has been elected as sponsored by the political party, and he has been duly elected. And the certificate also says the same thing. So Malaj, he should have assumed that they continue to be in the Shiv Sena, and that Shiv Sena had 52 members, and all the three parties together have 152 out of a house of 280. There was no occasion for him to say, have a floor test. He knows, because he is not a member of the assembly, but he is part of the legislature. So he knows. So he went outside the scheme of the 10th schedule as well as the scheme of the constitution to recognize a faction. Majority or minority doesn't matter.
According to you, suppose there is a split, which is now, of course, not recognized.
Yes.
So what would have been a split under the unamended provisions of of the 10th schedule? But there is a group of legislators who have otherwise left they say we have withdrawn support.
Correct.
Right? Whether they withdrew support here or not, that you already made your point. Now, they will incur a disqualification because there is no split which is recognized by the 10th schedule now.
Yes.
Can the governor not then look at the numbers and say that, assuming that these people say that we have left, whether they incur a disqualification will be decided by the speaker, but this conduct of these people in doing something which is contrary to the 10th schedule also is liable to affect the strength of the house and the strength of the number of parties in that house, or the strength of the party in that house. Can he not do that?
No.
Because your argument is he can't do that at all.
No, forget Malaj, the majority. This can happen, Malaj, where 2 or 3 or 4 members of each political party can do the same. What you're doing is, Malaj, when there was no 10th schedule, what used to happen? The same thing. What my lord is putting to me used to happen when the 10th schedule was not there.
Right.
So you are going back to a state where the 10th schedule is not there. That's my answer. Because that's exactly what your lordships are putting to me. Can't the governor, looking at the fact that these people now say they want to withdraw support, they may be disqualified. That's a separate issue.
Then your submission would be that the governor can't call for a trust vote in oblivious to the provisions of the 10th schedule.
No, forget the 10th schedule. He can't call for a trust vote, Malaj, by recognizing a faction in a political party which has no identity, which has no constitutional identity. That's my submission. Malaj, your lordships are now looking at them as a group. They are not a group, they are individuals. There is no concept of a group within the legislature. Each is an individual. And government formation is based only on alliances. And therefore, Malaj, calling a trust vote has to be based also on alliances, if it's been reduced to a minority. That's accepted now by Rameshwar Prasad, Malaj. They could have followed, Malaj, the Madhya Pradesh model. Resigned. No, but they wanted to be chief ministers and posts, Malaj, so naturally, Malaj. They could have followed the other model. Malaj, that also is a constitutional issue which one day your lordships will decide. That's also another issue. The collective decision to resign as a group, Malaj, is something which is very suspect in constitutional law. Suddenly, all of them together one day decide we all must resign.
This is in line with Quixote, unless we question Quixote.
Malaj, I have always questioned it. I have always questioned it, but that's another issue, Malaj.
But it also has a bearing on coalition governments,
Yes.
particularly regional parties.
Yes.
Regional parties, this argument could sometimes be very dangerous also, because there is absolutely no freedom in the party, except for one leader. Many a times it's a family which runs it. and there is no scope of anybody else coming into the fray
But in
and
fact,
setting up an alternative, because it's impossible.
Well-
Virtually, we are interpreting the constitution to say that it is just not possible for any legislator.
well, in fact, this has been my grievance. What happens, Malaj, in the United States and in the UK, Malaj,
Parties.
a president, Malaj, of the Republican Party will reach out to Democrats to get a bill passed. The insurance, actually, Barack Obama had to reach out to the Republicans for his insurance bill. And in the UK, the same thing, the Conservative Party or the Labour Party reaches out to the opposition members. There is no such thing as defection. This is the problem. But anyway, Malas, we are in another era.
Yeah.
At the moment, we are on the law as it stands today. So we go back to the Gairam regime, when there is no 10th schedule, and you can actually move the governor for toppling any government you want at any time you want. Yeah, a few people. Malas, there is an NCP case where only four people of the NCP, Malas, actually went away. There were only 4 members. All of them went away. So it can happen.
So according to, going back to the Sarkaria Commission report, which was relied upon in Rameshwar Prasad, this was a post-electoral coalition of parties.
That's correct.
Of course, with the support of some independents as well.
Yes.
So according to it is only if any one member of the alliance and
Shifts.
or one member of the coalition shifts,
That's right.
that the governor can then say that, look, as a result of one party in the coalition, one member of the coalition having shifted,
Correct.
or ceased to back the government. Therefore, I feel now your vote in your confidence in the House,
Yeah.
the confidence of the House in your government is now liable to be affected. Therefore, I call for a trust vote.
Therefore, he is not concerned with the 10th schedule at all, Malas.
Right.
With the greatest respect.
Right.
Governor is not concerned with it. That's a separate proceeding. Whether they'll be disqualified, they may not be disqualified. If they vote against the whip, Malas, within 15 days, I can condone it. Or if you have sent notices to 16, the others may say, now I don't want to lose my membership. They will come back. That arithmetic and that, Malas, the consequences are not relevant as far as the governor is concerned or even the court is concerned. Court is to judge the act of the governor on the 28th of June, Malas. Whether that was right or it was wrong. And I might say this to your lordships, Malas. Malas, when we enter this courtroom, Malas, we are in a different aura. We come with hope, with the expectation that you are the only hope in this country. Power, well, if you look at the history of civilization, all injustices are based on power. Whether it was the execution of Socrates, why was he executed? He was executed because he didn't believe in the Athenian gods. He was executed. The same thing is happening today. Not in that sense. Where do we go? Therefore, Malas, this court's history has been so phenomenal and your footprint is the largest around the world. You are the beacon, the hope of 1.4 billion people. And you can't let democracy be destabilized in this callous, uncouth fashion. I'm sorry, Malas.
But then taking your argument to its logical conclusion, that means that the governor cannot really have regard to any individual movement of a group or a number of MLAs or MPs.
That's Bomai, Malas. Yes, exactly. Para 88 of Bomai says that.
Lies within the province of the Speaker under the 10th schedule.
Internal dispute he can't deal with. Para 88 of Bomai, Malas. Intra-party disputes he can't deal with. It's in my note, I'll succumb to it. The Chief Minister said, I am ready to hold that test. And Para 3 was there on that day of the 10th schedule. And Malas, what did the governor do? 356. It's in that context that Bomai says, which is why I said the other day, these decisions are contextual. There's no general principle that can be applied across the board. There can't be. Freedom of speech is a general principle. How you will actually, Malaj, recognize it is the context. So, Malaj, in this connection, it is necessary, I'm quoting Malaj, I'm sorry. In this connection, it is necessary to stress that in all cases where the support of the ministry is claimed to have been withdrawn by some legislatures, the proper course for testing the strength of the ministry is holding the test on the floor of the House. That alone is the constitutionally ordained forum for seeking openly and objectively the claims and counterclaims in that behalf. The assessment of the strength of the ministry is not a matter of private opinion of any individual, be he the governor or the president. It is capable of being demonstrated and ascertained publicly in the House. So first you must reach a bona fide, constitutionally valid conclusion that this requires a floor test and on relevant considerations. If you are able to justify that to the court, then the only remedy is the floor test. Well, it's the next paragraph. I just read the highlighted portion, para 391 at the bottom. Whether the Council of Ministers has lost the confidence of the House is not a matter to be determined by the governor or for that matter anywhere else except the floor of the House, correct? Principle of democracy underlying our Constitution necessarily means that any such question should be decided on the floor of the House. The House is the place where the democracy is in action. It is not for the governor to determine the said question on his own or as his own verification, which is what exactly he did by recognizing a faction. Now let's kindly come to para 32. Thus, S.R. Bomai is not an authority for the proposition that the governor must order a floor test whenever a claim is made that the elected government has lost the confidence of the House, irrespective of whether such claim is based on unconstitutional or extraneous considerations. Rather, S.R. Bomai, it was categorically held that the power under 356 cannot be used to